So now we have spoken of the status of an intended beneficiary. We are aware of when we must discuss, if at all, the concept of the vesting of rights. And in the event of breach of the direct undertaking, we now know that the primary cause of action belongs to the intended beneficiary. And should it be commenced, we are very much aware of the fact that that promissor's defendant may raise any defense, be it real or personal, so as to defeat liability to the intended beneficiary, whose rights stand or fall on the strength of the contract made for his benefit. Finally, although immune from set-offs, the intended beneficiary is vulnerable to counterclaims, a counterclaim being any breach of the contract by B. Any damages sustained by A in light of B's breach may be established in that litigation, and if of a lesser dollar value, will diminish the recovery of the intended beneficiary by that amount. Equal or greater dollar value defeat the recovery, though there is never an affirmative recovery against an intended beneficiary. There's only one last thing they could ever ask or could arise in litigation respecting an intended beneficiary, and that is what rights, if any, in the event the promisor breaches, accrue to B, the promisee, who bargained for that performance, though he was not to receive it directly, who bargained for it and paid for it, supported it with valuable consideration. Since, under the terms of the contract, if it had been kept, B was not to receive the performance of A, which was to be directly delivered to T, in the event of breach on the part of A, B cannot recover a loss of bargain measure of money damages. That is because the money damages to B would be speculative in dollar amount. Since he wasn't to receive A's performance, we'd have to guess as to the dollar dimension of the harm done to B if A did not perform. Well, that means that in this circumstance, B has no adequate remedy at law, right? No adequate remedy at law, and wherefore would have standing to sue in equity. The suit that would be brought would be for specific performance, coercing A to deliver as promised to the third party. But as you will be told in your remedies review, there is no such thing ever as a right to relief in equity, merely a prayer for relief addressed to the discretion of the trial judge. And if for any of the numerous reasons specific performance were to be withheld, then there would be consolation prizes at law available. If B had already paid A, he could recover the value of the payment on a theory of quasi-contract. If B had changed position in detrimental reliance upon A's promise to perform, could recover in promissory estoppel. But here is the big rule. I've saved it for last. The only time you will ever discuss remedies or rights for B, the promisee, is if in the fact pattern the intended beneficiary has not brought the primary cause of action for A's breach. Right? Therefore, if the intended beneficiary brought and succeeded in recovering under the primary cause of action, that is the only relief available for breach of that contract, and B has no cause of action. So B steps into the picture with rights only if the intended beneficiary fails to assert the cause of action or refuses to do so. Only then do we get to the last residual question of the rights of the promisee. And as I said, just to briefly recapitulate them, generally no loss of bargain recovery of money damages at law because he wasn't to receive the performance, standing to try to equitably enforce the terms of the contract. If that is denied on discretionary grounds by the court, then any backward-looking remedies in the nature of restitution, quasi-contract, reliance, promissory estoppel. That is all there could ever be. If in your reading of the facts you encounter not only the parties who form the contract, but terms of the contract which identify some non-trader, T. So we are finished with intended beneficiaries. We now pass to the second of the three non-traders, and in so doing, we inject the only element of mystery and intrigue that can be claimed for the law of contracts, the introduction of a stranger. How thrilling. Those would be the rights and duties of assignees and delegates. How will you know that the question is in front of you on the exam? Again, the good news is these are the easiest questions to spot on the bar exam. If the original formation at stage one of your analysis, forming the elements of agreement, finding them, features an offeror and an offeree, and you reconstruct the terms of their bargain, and lo and behold, they make utterly no reference to non-traders. So the original bargain is a garden variety, two-party contract in which the promises exchanged by the parties call upon performance running to the other party to the contract. A makes a promise to B to perform directly to B. It is supported by a promise B makes to A, running directly to A. Oh, by the way, at about this point it may have dawned on you that I use these phrases promisor and promisee a great deal, perhaps more than you did in your contracts course. Let me make an elemental point very clear, lest I take it for granted. In every bilateral bargain, A is the promisor of his own obligation of performance and the promisee of B's obligation. B is the promisor of her own contract duty and the promisee of A's. So both parties occupy both positions. When we put the label on, it is for emphasis. A moment ago, we're talking about the contract duties of A, so we called him the promisor. We were talking about a duty that was assumed in a bargain with B, and so in my duty, or in my agreement with Vitagro, I was the promisee. But those terms are merely terms of convenience for labeling and analysis. If we have this arrangement, no non-trader mentioned, there never could be an intended beneficiary. Right? It couldn't be. Because the intended beneficiary is either identified and defined in the terms of the contract or does not ever exist. But if subsequent to the formation of this agreement, A takes the extraordinary step of identifying some stranger and seeking to transfer to that stranger the right to receive in whole or in part the performance that is still owed to A by B, then we know that A is attempting an assignment of contract rights. We now call A, who's made this attempt, the assignor. And the party to whom he would transfer the right to receive B's performance, the assignee. The assignee. There's yet another possibility. Subsequent to the formation of the bargain, B could take the extraordinary step of identifying some stranger in the marketplace and seeking to enter an arrangement with that stranger, under terms of which the stranger would assume primary responsibility for carrying out the terms of the promise that B has made to A. If B unilaterally seeks to create in Y primary responsibility for carrying out her contract duties, we would now call B the delegor. And the individual who is assuming the primary responsibility to carry out her promise, the delegate of her duty. Those are the two strangers, the assignee of rights, the delegate of duties. It could hardly be easier to distinguish what they're there for. Look at the purpose of the attempt. If it is to confer the right to receive benefits, you have an assignee. If it is to impose primary responsibility to carry out contract duties, you have a delegate. Of course, it would be possible to introduce the stranger for both purposes, to become the assignee of my rights under this contract, as well as the delegate of my duties. Right? Now, as I say, we're going to discuss these by first examining the common law status of the assignment of rights, and then talk about the common law delegation of duties. But before I do that, it's time for me to give you some major truths about both assignment and delegation, an appreciation of which I think will help you, at least I surely hope it will, in dealing with these topics. There are three general propositions you'll want to know about the introduction of a stranger. First, the same bias of the modern law in favor of contract formation is now reflected in a policy which positively favors the freedom of assignment. Modern common law positively favors the freedom of assignment and is increasingly tolerant of the freedom to delegate duties. Second, in any fact pattern where the assignment of rights or delegation of duties is proper, it may be accomplished without the consent of the other party to the contract. Both the assignment of rights and delegation of duties are wholly unilateral legal privileges, the exercise of which does not depend upon the prior or contemporaneous consent of the other party. That's the second major proposition I want you to understand. And the third one, since both the assignment of rights and delegation of duties take place without the consent of the other party, they are never appropriate when the result would be to add to or vary the obligations undertaken by the other party to the contract, or to prejudice or vary the performance to which the trader was entitled. Never appropriate if the result would be to add to or vary the duties of the other trader, or prejudice the security or vary the quality of the performance owed to that party. Therefore, if you conclude that an assignment of the right by A to X to receive B's performance would add to or vary the obligations which B had consented to at the formation stage, there is no appropriate case for an assignment. Likewise, if you conclude that a delegation by B to Y of the duties which B had assumed in forming the contract with A would prejudice the security which A had enjoyed, or the quality of the performance which A would now receive, there is no appropriate case for delegation. If you keep those three major propositions in mind, then as the law unfolds in detail, you will have utterly no difficulty in dealing with it. Let's begin by paring the possibilities back. For the time being, we will eliminate the delegation situation and simply go back to the simple two-party transaction. At the formation stage, we simply have an agreement, an executory bilateral contract between A and B. Now again, what makes these the types of questions that I look forward to on exams, if I'm taking one, is I want questions that I can easily spot, that cannot be snuck up on me. Well, they cannot sneak an assignment problem up on you. They will form the contract at the formation stage with no mention of non-traders. Again, I make the point there could never be an intended beneficiary. Subsequent to the formation of the contract, while it is still executory, meaning the parties have exchanged promises but they've yet to perform, suddenly A will take it in mind to do an extraordinary thing, to identify out in the marketplace a non-trader and seek, without the permission of the other party, unilaterally attempt to transfer to that non-trader the right to receive the performance owed to A by B. We leave labels now. We speak of A in these circumstances as the assignor, X as the assignee. And now we're going to put a new label on B, because the subject matter of this attempted arrangement between A and X are the obligations which B has assumed under the contract, her contract duties. And so we call B the obligor. We're talking of her contract obligations. Right? Now, whenever you find that factual development in an examination question, there are only 4 possible issues that could be raised. Right? The first thing I want you to do when faced with this fact pattern is to ask this: do I find a present assignment? Yes or no? If the answer is no, the question's over. Second, assuming that I found a present assignment, is the assignment between A and X operative? Is it an operative assignment? I'll explain the term in a moment. Third, if you found a present operative assignment, is that assignment revocable? I'll explain that. And fourth and finally, if X achieves a present and operative assignment, and if the assignment was either irrevocable or there has been no problem with revocation, the legal consequence is that the legal right to receive the performance which B had originally promised to A has been extinguished in A and has become the exclusive right of X, the assignee. In the event of B's refusal to perform or defective performance, the cause of action to remedy that breach of contract is now that of the stranger, the assignee. In the event that the assignee were to commence a cause of action against B for breach of the contract assigned, what defenses may the obligor raise so as to defeat or diminish liability to an assignee? Those are the only possible issues. And again, the facts will show you which ones you will want to discuss. Well, let's take them one at a time. The elements of present assignment. Present assignment. There are no magic words necessary to create a present assignment from A to X. All that is required is the manifestation of a present intention on the part of A to achieve a present transfer of her present rights to X. Those are the elements of a present assignment. Thus, by any words or combination of words and acts sufficient to describe and identify the subject matter that is being transferred, A, as the assignor, must wholly and immediately divest herself of all right, title, and interest in the subject matter and transfer that interest to X. That is the essence of a present assignment. Right? A present assignment. What are the fact patterns that offend the requirements of present assignment? Well, first are fact patterns that question the intention of A as the assignor. Now, what is it that the law requires? For whatever reason may motivate A to make the assignment, there is no present assignment unless A objectively manifests an intention to make the assignment right here and right now. That's a present assignment. Right? A statement by A to X that next week I will assign to you rights under my contract with B is not an assignment. The only way A can act is in the here and now. Again, there's no magic formula that must be observed, but the facts must manifest on the part of A present intention to act in the here and now. That's the requirement of present intent to make a present assignment. The second element, there must now be steps taken in the present by A that are sufficient to act upon her intention. What are those steps? The steps of present assignment. First, she must clearly identify the subject matter of the proposed assignment to X. Therefore, if A clearly manifests an intent to act in the here and now, but doesn't clearly identify the subject matter, there is no assignment for the common sense reason that X doesn't know what he got. So the first step of present assignment, that A clearly identify the subject matter to be transferred. The second element of present assignment, the steps, that with regard to that subject matter, A manifests a present intention to totally divest herself of all right, title, and interest and to recognize that it is now exclusively and immediately the property of X, the assignee. Right? And finally, that present intent, coupled with those present steps, must relate to what the common law calls a suitable present subject matter. A suitable present subject matter. Now, if there is an executory contract already existing between A and B, that is exactly what the common law looks for as a suitable present subject matter. Right? Future rights, rights to performance in the future, which are already defined by an existing contract, may be freely assigned. Right? So if the contract between A and B calls upon B to pay A $10,000 on the 15th of March, 1990, at any time subsequent to the formation of that contract and prior to the 15th of March, there is a suitable present subject matter which A may assign to X. Future rights under terms of an existing contract freely assignable. What about future rights under a future contract? If there is no contractual relationship between A and B on the day that A attempts the assignment, there is no present assignment at common law for the common sense reason that there's nothing to assign. But there is an intriguing exception in equity. An equity court would permit an assignment today by A to X of a future subject matter involving the obligations of B, though as of today there is no contract between A and B, provided there is an established economic relationship between A and B that supports A's expectation of a future contract. Up in my neck of the woods in Northern California, we use this all the time to support the agricultural industry. Farmers go out and borrow money from banks every spring. And what do they pledge as security? The monies that they will receive from the purchasers of the crops that are harvested in the late fall. There is, however, yet no contract. But there is an established economic relationship between the farmers around Davis and the 5 cooperatives around Davis that habitually buy their crops. And so there can be in equity, using the machinery of a resulting trust, a present assignment. The assignment works as follows. As far as equity is concerned, the assignment has taken place. If the economic relationship generates the anticipated contract, then the only thing that the assignor has is bare legal title to the subject matter. The equitable interest in the subject matter already belongs to the bank as the assignee, and it may bring a suit to unite the equitable claim with the bare legal title. What about the attempt today by A to assign to X rights in a future contract that he anticipates or hopes to form with B, and yet there's not even an established economic relationship between A and B generating that expectation? Well, that's the attempt to assign a dream, and that is an impossibility either at common law or in equity. And so to review where we've come so far, we have just established the elements of the doctrine of present assignment. They involve the manifestation of an intent on the part of the assignor to act right here, right now. That intent coupled with steps of present assignment sufficient to identify the subject matter and to clearly extinguish the interest of the assignor and transfer the same to the assignee. And finally, that intention and those steps must relate to what is a suitable present subject matter. Generally speaking, we mean executory rights under an existing contract. Since this is all a unilateral privilege on the part of A, B has not consented